Jefferson County Code at Law number 2 is now in session. The court is in session with the motion to revoke probation docket and the announcement docket on today's date, July 10th of 2024. Mr. Paget?
Yes, Your Honor, may I approach?
Yes.
Yes, Your Honor, I have two cases, but one on your announcement docket is Darwin Nunez Perez. And he is inside the courtroom, Your Honor.
Mr. Perez, would you please come forward?
My other one is Mr. Simon, and we're going to go down to the criminal district court. He has a felony today, and then we'll come back.
Okay, now do you want to take care of Perez right now?
If we could, Your Honor. So he
Okay.
works in New Orleans. And
Okay, Mr. Perez, would you please come forward? Mr. Perez, your full name is Darwin Aura Nunez Perez?
Yes.
How you doing, Mr. Perez? That's good. I'm doing fine. Thanks for asking, Mr. Perez. You're representing your case by your attorney James Paget. Attorney Paget, how are you doing?
Doing well. Good morning.
Good morning. State is represented in this case by Attorney Andrew Huber. Attorney Huber, how are you doing?
Doing well, Your Honor, and yourself?
I'm doing fine. Thanks for asking. Mr. Paget, what is your announcement?
Your Honor, we have received an offer from the state this morning that my client's inclined to accept. We have a few things that need to be done. I would ask if you would put this on a plea certain docket, if you would give my client 60 days. He's tying up a few things in New Orleans, and then he will be back in town.
Give us a reset.
But what day is it?
September, what day?
Is there any way we can do a Wednesday?
What about the 11th or the 13th?
Whatever pleases the court. It's just the Monday's tough for me this summer. That's perfect.
So that's September 11th. Okay, Mr. Perez, or Nunez Perez, your case will be reset to September 11th of 2024. Once you get your reset from your attorney, you're free to go and you have a blessed day.
Thank you. Your Honor.
And Mr. Patch, you said you're going to be going to another court with
Mr. Simon
Simon?
has criminal district court. Now, I'll need to step down there. I'm certain
Okay.
he'll probably be here.
Okay,
But I will let the court know if he's not here.
okay,
Otherwise, we'll be back down here.
okay, fine.
Thank you, Your Honor. May I be excused?
Yes, you may.
Thank you. It's fine. I'm looking at it. He's just going out with his wife.
Morning, Judge Matheridge.
Yes.
I'm here for Lorenzo Walker on the announcement document.
Okay,
He's present.
this is cause numbers 24 CCCR 0472 and cause number 24 CCCR 0475. Both cases are style of state of Texas versus Lorenzo Walker. Mr. Walker, would you please come forward? Each some bond conditions. Mr. Walker,
Thank you.
your full name is
I'll see you then.
Lorenzo Walker.
Yes, sir.
How are you doing, Mr. Walker?
I'm doing good. How you doing, sir?
I'm doing fine. Thanks for asking. And you're represented by your attorney Alec Comerford. Mr. Comerford, how are you doing?
Doing well.
That's good. State is represented in this case by attorney Haley Simmons. Ms. Simmons, how are you doing?
I'm great, Judge. How are you?
I'm doing fine. And Mr. Comerford, what is your announcement in Mr. Walker's cases?
We just received discovery today, so I just need to reset to review that and then go over the offer.
Okay. I need to give Mr. Walker some bond conditions in this case. Mr. Walker, I'm going to go over some bond conditions with you. You'll be able to get a copy of these bond conditions from your attorney. We're going to make a copy for you. The document is titled Standard Bond Conditions in County Court at Law number 2. And it states as follows: following return of a criminal information in County Court Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number one, the defendant shall commit no offense against the laws of this state, any other state, or the United States. Do you understand that condition? Condition number two, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol and the test indicates the presence of drugs or alcohol in the defendant's body. Do you understand that condition? Let's see now, condition number 3 and condition number 4 does not apply. However, a condition number 5 does apply. And condition number 5 states the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by section 1.07 the Texas Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. And Mr. Walker, do you understand that condition?
Yes, sir.
Now, Mr. Walker, if you violate any one of these conditions, your bond can be revoked, and if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand? Okay. Now, your attorney is going to get you reset, and we'll give him a copy of these bond conditions. Once you get a copy of the reset and the bond conditions from your attorney, you'll be free to go, and you have a blessed day. And I think, Attorney, come forward. These are the only 2 cases you have today?
Correct, Judge.
Okay, you'll be free to go as well, and you have a blessed day. Just please stand in front of the court coordinator.
You can stand on there.
Yeah, y'all can stand in front of the court coordinator. And just wait a minute for what's this? Here you go. What was that court date? September 11th, 911. Yeah, just wait a minute. She's gonna give you a copy of his bond conditions. Let's see. That's Wallace. Oh, yeah, I see that. Terrence. Y'all free to go, and y'all have a blessed day.
And does he get a copy as well, or is it just?
Oh, that was his copy.
Okay. Good.
Yeah.
Can I get a copy?
Yes, make another copy. And she'll make another copy.
Sorry, thank you.
Right now. Actually, I have 2. Well, one of them, Gertz represent him on the on another case. Max Robert Colbert. Good morning, Mr. Colbert. Your full name is Max Robert Colbert?
Max Dale cover, yes, sir.
Max Dale?
Yes, sir.
Okay, but you have, yes, Max Robert, okay. Now, Mr. Colbert, how are you doing?
Make it through the storm and whatnot.
Oh, okay. I hope you,
I live over in Winnie.
oh, you okay. So you had a little bit more wind than we had, and
Yeah, a
rain
little bit,
and
yes, sir.
water, yeah. Well, I hope everything's all right for you.
Oh, yes, sir. We made it out of it.
Well, that's good. Now, Mr. Colbert, you're representing your case by your attorney, Attorney Langston Adams. Attorney Adams, how are you doing?
Doing good. Thank you, Judge.
Mr. Adams, what's your announcement in Mr. Colbert's case?
Judge, if you don't mind, can I hold it? I just got the MTRP today, so I want to reset it to have him come to office and we go through.
Okay, State, you have any objections?
No objections, Your Honor.
Okay, give us a reset date.
August 14th.
Okay, this case will be reset to August 14th, 2024. Mr. Colbert, you're gonna get your reset from your attorney. Once you get your reset from your attorney, you'll be free to go now. Mr. Colbert, need to let you know that you're still on probation. So you still have to abide by the terms and conditions of the probation. You're still on probation. All right. Now, Mr. Colbert, your attorney is going to get your reset from our court coordinator. Once he gets the reset, you're free to go and you have a blessed day.
Thank you.
Thank
And
you,
Mr. Adams, I think this is your only case. You're free to go as well and you have a blessed day.
Appreciate you, appreciate it.
Next, who you? Okay. Next case is Bruce Wayne Green. Mr. Green, your full name is Bruce Wayne Green. Okay, this is cause number 24CCCR 0104. Let's see, Mr. Green. Mr. Green, you appeared in court. Is that March 5th of 2024? At that time, you fill out a document that's titled Judge's Explanation of Rights of Defendants Without Attorney. And on that document, you said you wanted your case reset so that you can hire your own attorney. Is that correct?
Yes, sir. I got a lawyer, Chad Edwards, out of Liberty County.
So you have a lawyer?
Yes, sir. He told me to come and ask for a reset again today. Today,
Well, if you have an attorney, your attorney was supposed to send a letter of representation, basically informing the court that he has been hired to represent you.
So I need to do my phone call.
You could make a phone call. You could go in the hall and make a phone call.
I don't know if it mean nothing, but he sent me like a screenshot of his docket telling me that.
Okay, but that's,
Of him telling me to ask for a reset.
well, that's two different things. Did you hire?
Yeah.
Well, he's still supposed
I
to,
already didn't work with him before.
okay, well, he was supposed to, you need to tell him that, we need to verify that. Okay, you can step outside and make your phone call.
How would I do it though? I gotta come verify with one of y'all.
You could go in the hallway.
But how do I get him on the phone with one of y'all to verify?
Well,
What I do?
if you get him on the phone, there's a lady who we can give him the number. You're gonna get the number from her. She's gonna give you the number and then he's gonna call in here.
I'm not sure if he's gonna answer that though. He told me-
Well, I don't know. We don't know if anybody's gonna ask when we make a phone call. You just have to make the call.
Just asking what's my other ways of going around it.
You're gonna come back in here if you unable to contact, and then we'll cross that bridge when we get to it.
Sir, thank you, Judge.
Okay. Mr. Reynolds, you have a client that's in custody?
Yes, sir. He's currently in drug court. I went down and visited with the prosecutor and the defense attorney. He's gonna enter a plea this morning. Part of that plea is that this misdemeanor case is gonna be dismissed.
Okay, so once
I get
she,
it reset for a couple of weeks, make sure.
well, once she verifies it's reset, we'll just, the case will be dismissed.
Okay,
I'm just confirming with Chris right now.
We don't have to just
okay, we
keep it on the docket.
it hadn't gone through yet.
We understand, but we anticipate that it's gonna go through today.
Okay,
So if it goes through today, sometimes today she'll get the confirmation from the prosecutor in that court, and then she'll dismiss the case,
okay.
if that's the agreement.
Yes, sir. Well,
Okay.
So am I free to go for today?
Yeah,
I'll dismiss it once I have confirmed and.
yeah, you don't have any other cases, right?
No, sir.
Okay, so you're free.
Thank you.
You're welcome. That's Mr.
Murray. M-U-R-O.
Okay, what are you doing? You ready on Mr. Muro?
He's president. We're gonna ask for 60 days.
Okay, Mr. Muro,
This is his first.
would you come forward? Oh, this is his first court appearance?
Yes.
Okay. And the prosecutor is Mr. Hubel. And this is cause number 24 CCCR 1006, case of style state of Texas versus. Is that Udork?
Eudork. Eudork.
Eldork?
Eudork.
Okay, Eldork Muro.
Yes, sir.
Okay, how are you doing, Mr. Muro?
Thank you.
That's good. Mr. Muro, you're representing your case by your attorney, Attorney Willard Hall. Attorney Hall, how are you doing?
I'm doing great, Your Honor. Thanks for having
That's good. Now, Mr. Hall, well, the state is represented by Attorney Andrew Hubel. Attorney Hubel, how are you doing?
Still doing well, Judge.
Okay. Now, Mr. Hall, what is your announcement in Mr. Muro's case?
We're asking for 60-day reset. He lives and works in Lake Charles, and he lives in Lumberton, but he works in Lake Charles. And we're going to ask for pretrial diversion in this case. I want to visit with the prosecutor for a minute.
The next free trial is August, right?
I believe so, Your Honor.
So the one after that is October, so we're gonna reset him in October, anticipating that he gets in the pretrial diversion program.
He has some medical issues as well. So
Okay,
that would
okay.
be-
So we'll do it, because it's too late probably for you to get into the pretrial diversion for the sign-up date for August. But the next one after that will be October. Okay, give us an October date after, maybe the second week. Okay, October 14th, that's good. Okay, this case will be reset to October 14th, 2024. Mr. Muro, your attorney is gonna get your reset. Once you get your reset from your attorney, you're free to go and you have a blessed day.
Thank you, Your Honor.
Okay. Okay. Muro. Okay. Oh. Green is calling
Yes.
his attorney. His attorney's office. Now, Miss Barella Jackson, you gave him the number to,
And the fax number, he got it. I want to have him exactly what to do.
The Zoom, no.
Oh, okay, okay,
And
thank you,
make sure he corrected his attitude the next time he come to my court.
okay,
And to be very responsible.
okay. Now, we waiting for attorneys on the other cases.
He and the harm.
I think it was, wait up, I think I have the empty.
Okay.
Yeah, Strother. He doesn't have an attorney.
Wow.
Now, this is cause number M 334-164. Case is style of State of Texas versus Christopher Strother.
Yes, sir.
How you doing, Mr. Strother?
Pretty good, myself.
I'm doing fine, thanks for asking, Mr. Strother. Let's see. Is this your first time in court on your motion to revoke probation case? It is? We need to give him the clipboard with the judge's explanation. No, I'm going to go over that document with you in a few seconds. Now, the first page on the clipboard is titled Judge's Explanation of Rights to Defendants Without Attorney. You see that?
Yes, sir.
Now, let me do this. Do you have a copy of his motion to revoke? Hold on a minute. Maybe I could just look it up over here. Well, let me look it up in a file. Okay, Mr. Strother. I have before me a motion to revoke your unadjudicated probation that was filed by the Jefferson County District Attorney's Office. In this motion, it alleges that you, Christopher Strother, was tried in County Court at Law Number 2 of Jefferson County, Texas on January 3rd of 2024 for the Class A misdemeanor offense of assault bodily injury.
Yes, sir.
The court found that the evidence was sufficient beyond a reasonable doubt to support a finding of guilt for that charge. However, the court deferred adjudication of guilt and placed you on unadjudicated probation for a period of 1 year. In this motion, Mr. Strother, there are 3 allegations. First allegation alleges that you, Christopher Strother, failed to pay court-assessed fees as ordered by the court, and as of April 17 of 2024, that you were $600 in arrears in violation of condition 9 of your probation order.
Yes, sir.
Allegation number 2 alleges that you, Christopher Strother, failed to perform the community service hours as required by the court in violation of condition 17 of your probation order. And allegation number 3 alleged that you failed to immediately report to Jefferson County probation each month by web or mail for months of February 2024, March 2024, April 2024, as ordered by the court in violation of condition 4 of the special amendment dated January 10th, 2024 of your probation order. And Mr. Strother, if the court finds that any one of these allegations are true, your probation can be revoked. And if your probation is revoked, you can be assessed punishment up to 1 year in the county jail. Do you understand that?
Yes, sir. Your Honor, in addition to those allegations, the state has become aware of a new charge, a felony charge out of Orange County. And it's the state's understanding that the probation officer on this case intends to file an amendment motion with that new allegation.
Yes, sir.
Okay, so what he's saying is that this is the first motion to revoke your unadjudicated probation. They're going to probably file another one with let me do this here. Now, you have a right to remain silent. Anything that you say can and will be used against you in a court of law. You have a right to have an attorney. And you have a right to have an attorney present during any questioning. Okay. Now, we're going to go over your right to have an attorney in a few minutes. But what I was saying is that they have this motion that's filed. However, they will be filing an amended motion. In essence, they're going to add something else on to the motion. But right now, this is the only motion that we have filed. And so, as I mentioned earlier, if any one of the allegations, if the court find any one of the allegations are true, you can be assessed punishment up to a year in the county jail. Do you understand that? Now, as a defendant in a criminal case, you have a right to have an attorney. The document that's on the clipboard that is titled waiver, that's titled Judge's Explanation of Rights to Defendants Without an Attorney, it states as follows. As a defendant in a criminal case, you have three options regarding your right to have an attorney. Number one, you may hire an attorney. Do you understand that option? Number two, if you want an attorney to represent you, but you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. And number three, you may represent yourself. You understand that those options. Now, if you want to have an attorney to represent you and you have enough money to hire an attorney, your case will be reset. Reset means you'll be given another court date so that to give you time to hire an attorney. If you want an attorney to represent you, but you do not have enough money to hire an attorney, you must first fill out a financial questionnaire. Okay, and the financial questionnaire is the document on that clipboard that is titled Jefferson County Affidavit of Indigence. You'd have to fill out the first page and half of the second page of that document. Do you understand? Now, once you fill out that document, then the proper person will determine whether or not you qualify to have an attorney to represent you. Now, if you want to represent yourself, that is, you want to waive your right to an attorney and represent yourself, you'll have an opportunity to talk to one of the prosecutors in the case to see whether or not you can work out a plea bargain agreement. Now, you cannot talk to the prosecutor about the case unless you first sign a written waiver of your right to be represented by an attorney. Now, the written waiver is the document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding Trial. That is another document that is on the clipboard. Now, you should be aware that there are dangers and disadvantages to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to waive your right to an attorney and represent yourself, you may change your mind at any time and request that an attorney be appointed to represent you. Now, at the bottom of that document, it states in bold letters, defendant's choice, mark initials next to only one choice. If your choice is to hire your own attorney, then you'll place your initials on the first line to the left. If your choice is, if you've already hired an attorney to represent you in your case, then you'll place your initials on the second line to the left and the name of the attorney in the line to the right. If your choice is to apply for a court-appointed attorney, then you'll place your initials on the third line to the left. If you have already been appointed a court-appointed attorney to represent you in your case, then you will place your initials on the fourth line to the left and the name of the attorney in the line to the right. If your choice is to waive your right to an attorney and represent yourself, then you will place your initials on the fifth line to the left. Now, once you have finished initialing one of the 5 lines, then you will sign your name at the bottom of that document on the line that is titled defendant. And you will date it today's date, July 10th of 2024. Do you understand?
I just wanted
Okay.
Last, do you want me to put where this says the state of Texas first, or do you want to put my?
No, we'll fill that portion out. Mr. Bailey, could you please hand me his document to see what he chose? Okay, now, Mr. Strother, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you'd like to have your case reset to hire your own attorney?
Yes, sir.
Now, before you sign and initial this document, did you read this document?
Yes, sir.
Did you understand what you read?
Yes, sir.
Is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Okay.
I'm sorry. Good.
Yeah, hold on a minute. Let me finish filling this out. Now, let me do this here. Now, Mr. Strother, I inform you that you have a right against Fifth Amendment right against self-incrimination. And that simply means that anything that you say can and will be used against you in a court of law.
Yes, sir.
You have a right to have an attorney. You have stated to court that you like to hire your attorney.
Yes, sir.
Now, your attorney could be present with you before and during any questioning. Do you understand that?
Yes, sir.
So I cannot talk to you about your case.
I'm just asking about my probation. Like I've tried calling up there.
Well, there's a probation officer here. You just, once we finish, you'll have an opportunity to talk to him. Okay, now, Mr. Strother, your case is going to be reset to give you an opportunity to hire your own attorney. And you should be mindful or reminded rather that you are still on probation. And so you are still required to adhere to the terms and conditions of your probation. Do you understand?
Yes, sir.
And you'll have an opportunity to talk to one of the probation officers
Yes, sir.
about the case. Now, Mr. Strother, you're gonna have a seat in that first chair? Okay, no, she's ready for you. Just stand in front of the court coordinator. She's gonna reset your case. Once your case is reset, you're free to go, and you have a blessed day. Okay, let's see. Okay, we'll get him to come back in. Yes, you're free to go. You have a blessed day. You can get Mr. Green to come back in.
So she called?
Yeah, that she's on hold.
Okay.
Let's see. That's what we verify.
You're on the,
Hold on a minute. Okay, now, we have, the secretary online, is that correct? You gonna put it on speaker? What she said? Okay, this is, the court is in session in cause number 24 CCCR 0114. The case is filed State of Texas versus Bruce Wayne Green. We have Mr. Green before the court, prior to, the court taking a break on this case. Mr. Green, informed the court that he hired an attorney in, is it Winnie? In Liberty County. And that, and so we had Mr. Green to contact that office. We have his secretary who, is on the line. Is that correct?
Yeah.
Okay. And, Mr. Green informed us that he hired, the attorney in this case. Did he hire the attorney?
He's in the process of hiring the attorney.
Okay, so he's in the process. Okay. All right. Thanks a lot.
Thank you.
All right. You have a blessed day. Okay. So, yes.
Oh, man, that's me and Mr. Chad had, we had talking that words, that was my fault, because I wasn't on top of him. Yeah, so that's why I misunderstand, but I've been high. His assistant trying to give me a lot of time, it's not about being high. That's all I just need.
Well, as far as they're concerned, you haven't hired him yet, you're in the process. Okay, and that's where we are. Now, that's not gonna change what I'm getting ready to do. Okay? So if you're in the process of hiring him, this is the question I need to ask you. How much time do you need to finish hiring?
I was gonna go there today, as soon as I got done with this.
Okay, so what I'm gonna do, I'm gonna give you a standard reset, and our standard reset is 30 days. Now, let me tell you what's gonna happen. Once you finish the process of hiring him, he's going to send this court a letter of representation informing this court that he has been hired to represent you. And what's probably going to happen is once he sends a letter of representation, the court date that we give you today is probably going to be changed to another court date further out to give him time to prepare so that he can represent you. Do you understand that? Okay. So right now, we're gonna reset the case, give you an opportunity. We're gonna reset it. Standard reset is 30 days. Okay, it's gonna be reset by August 16th. Give you an opportunity to finish the process of hiring the attorney. And what's his name?
Chad Edrich.
No.
Edrich?
Yes, sir.
Okay.
ETH. He took it for IT chief.
Right,
It's not signed.
okay. Chad, okay.
I didn't please sign.
Okay, so we'll give you an opportunity to finish hiring Mr. Attorney Chad Ettridge. And then once Mr. Ettridge is hired, he's gonna send a court a letter of representation. But in the meantime, your court date is August 16, 2024. Once you get your reset, you'll be free to go and you have a blessed day.
Okay.
That door is locked on that side. You gotta go out the other door. Okay, so do you have a dismissal? Jefferson County Court at Law number 2 is back in session. The court is in session with the announcement docket and the motion to revoke probation docket. Mr. Paget,
Yes, Your Honor.
you had a matter.
Yes, Your Honor, I'm approaching on Mr. Braylon Simon, who's
Okay.
present in your courtroom.
Mr. Simon, would you please come forward?
Yeah, I checked in for him earlier, Your Honor, and we had been down to criminal district court, so we're back
Okay.
to make our announcement.
Now, this is cause number 23 CCCR 0550. Case is style of State of Texas versus Braylon McKay Elton Joseph Simon. Mr. Simon, is that your full name?
Yes, sir.
How are you doing, Mr. Simon?
Pretty good. You?
I'm doing fine. Thanks for asking, Mr. Simon. You're representing you by your attorney, Attorney James Paget. And Mr. Paget, what is your announcement in Mr. Simon's case?
Your Honor, Sarah Staub in the criminal district court's handling Mr. Simon's felony. I anticipate that we will be able to work that case out on the next court setting, which is on August the 21st. The state has not contacted the complaining witness in that case. Therefore, they requested a reset. I'm going to do everything I can to make sure we have everything tied up if you would allow us to come back on that same day.
Okay, so you state you have any objections?
No objections, Your Honor.
Okay, so this case will be reset August the 21st of 2024. And Mr. Simon, your attorney is going to get you reset. Once you get your reset from your attorney, you'll be free to go. And you have a blessed day. And Mr. Paget, I think this is your
Yes,
last
Your
case.
Honor. I'd also like to let Mr. Simon know that when he does come back here, if he could check in here first, and then we'll go down to the felony court.
And then come back here.
Because it makes it easier on the judge. That way I don't
Okay.
have to come down here. All right?
Okay, Mr. Simon, you have a blessed day. And Mr. Paget, you get your reset.
Thank you, Your Honor.
You have a blessed day as well. You are, yes, you may be excused. Oh. We have Mr. Hall. Mr. Next case is cause number 23CCCR 1266. Case is style of State of Texas versus Derek Anthony Campbell. Mr. Campbell, would you please come forward?
How you doing, Judge?
All right, how you doing there, Mr. Campbell?
All right.
That's good. Now, Mr. Campbell, now you have your mother with you?
Yeah, I got my mama with me.
Okay, how you doing, ma'am? I'm doing fine, thanks for asking. Now, you're representing your case by your attorney Giles Cole. Mr. Cole is not here at the moment. However, the state has informed me that they will be dismissing your case.
Come on now.
Yes.
Come on now.
Yeah, and so is that correct, state?
That's correct, per request of the complaining witness in this case.
Okay, and so I'm going to sign your dismissal.
Okay. So
Actually,
I ain't gotta come back?
this is it. All right, so case is being dismissed. You're gonna get a copy of the
You be
dismissal.
good, Judge. I've been taking my medicine though.
That's,
I've been trying to take my medicine.
that's good, that's good. All right. So more or less, just stay on the right track.
I'm trying.
You know, the road to recovery is not a sprint, it's a marathon. And what I mean by that, a marathon is a long race. Okay, and so if you know, like I know, you active for a long time. If you're running for a long time, you get tired.
You get tired.
You're gonna get tired along the way, and so that's how it's gonna be. You're gonna get tired along the way, but when you get tired along the way, you should understand that you have people that you can lean on to support, like your mom.
Like my mom. That's all.
That's right, and like
Family.
your family and the people that's helping you. Okay, so you just need to lean on them.
Buck, I got an uncle named Buck, so he helped me.
That's good. And I always tell people this. Now, you know, a lot of times people always say that they have friends and their friends had a back, right? But what I noticed just from practicing law, a lot of times when they say, oh yeah, my friend got my back, he's my ride or die, or she's my ride and die, on days like today, when you're in court and you need their support, they're not here. But guess
So
what?
I'm patient too.
That's
I'm
right.
Patient.
That's right. But the person that's here is your mom. You know why? I tell people this all the time. Everybody's not your friend. Everybody's not your partner. But when that lady right there says she's got you, she's got you.
Okay,
That's your ride or die.
okay.
So if you need any help, you need somebody to lean on, you can lean on her. And ma'am, thanks for being here and thanks for supporting your son. He's gonna get his dismissal. Once you get a dismissal, he's free to go. And y'all have a blessed day.
You too.
All right,
Thank you, ma'am.
all right.
Thank you, Judge.
You're welcome.
Bye. Bye, Mr. Campbell.
Okay, Mr. Gertz.
Well, may I say something before I
Yes.
call my cases? So, Judge, I've got a hearing in federal court at 10:30 that I'm
Oh.
doing by Zoom. It's in a DC district court.
Oh, okay,
And so I've got one announcement that would be really quick. And then I've
Okay.
got two that I'm trying to work out plea deals on.
okay, what we'll do is you make that real quick announcement. We'll let you go take care of the hearing on Zoom and then you can come back and we can take care of the
And
other
I'll
two.
just be right next door. I won't be going.
Okay.
there, but it-
Who, which one?
It's on
Which one is
Wallace.
real quick?
Yeah,
Wallace?
yes.
Okay, next case is cause number 23CCCR 2415. Case is style of state of Texas versus Daniel Paul Wallace. And Mr. Wallace, we also have another case, cause number M333321, Daniel Paul Wallace. Now, Mr. Gertz, I see that you're the attorney on this first case. The second case, is that an MTRP?
No, Your Honor, that's a Class C appeal.
Oh, a Class C appeal. Oh, this was a case that was transferred from next door?
Right.
Okay, so what we'll do, what is your announcement on his case that you're hiring on?
We're just going to ask for additional time. This is our first appearance.
Okay.
And we've got a bunch of stuff to review
And
and then
give us a reset date? 9/11. Okay, this case will be reset to 9/11/2024. We will also reset the second case to that same date. That'll give you and your attorney opportunity to talk about that case and see if whether or not you need to hire him on that case as well.
and I think he will and has, Judge.
Yeah.
At least we've talked about it.
Okay, so we just need a letter of representation.
Yes, Judge. I think
Okay.
last I heard, I thought we were still in the
Oh, you
municipal
know what?
court, but it's not important. We'll get it sorted out, Judge, is the answer.
And you said that was 9/11 at what time?
At 9 a.m. Yeah, all our cases start at 9 a.m. Okay? You're gonna get your resets from your attorney. Once you get your resets from your attorney, you're free to go and you have a blessed day.
Thank you, Your Honor.
All right. Yeah, but yeah,
Judge, I'll be right next. door.
Okay.
It's just a status conference. It should take 10 to 15 minutes, but
okay. Yeah,
who
okay.
knows?
All right.
Thank you.
How long is your? I'm not gonna interrupt you.
This one, thanks.
You having a good day today? Well, feeling better now.
Mr. Beasley, your attorney, Mr. Burbank, is in drug court in the building next door. So once he comes over here, we'll call your case back up, okay?
Okay, no problem.
All right, you can maybe put your video, you can turn your video off and put your mic on mute.
Okay, how do you take the video off, you know?
I don't know how to do it on your thing. On your end, it just says, on my end, we just say stop video, but you can just leave it on there.
Okay,
Okay, Mr. Beasley, you can take your mic off of mute. Your attorney's here.
Oh, what?
Y'all still talking or y'all? That's Andrew's case?
Yes, Your Honor.
Do y'all need to talk?
Have a second, Judge.
Okay. Jefferson County Court, Law number 2 is back in session. The court is in session with the motion to revoke probation docket in cause number M321946. The case is styled the state of Texas versus Brandon Javon Beasley. We have Mr. Brandon Javon Beasley, who is appearing via Zoom. Mr. Beasley, how are you doing?
I'm good. How are you?
I'm doing fine. Thanks for asking, Mr. Beasley. You're representing your case by your attorney Tom Burbank, who is appearing here in court. Mr. Burbank, how are you doing?
Doing fine, Judge.
That's good. Now, the state is represented in this case by Attorney Andrew Hubel, and the probation office is represented by Mr. Garrett Gilliam. And again, Mr. Gilliam, how are you doing?
Fine, sir, thank you.
Okay. Now, Mr. Burbank, what is your announcement in Mr. Beasley's case?
I've talked to the state judge. They have made a tentative agreement offer here. I just need some time. Mr. Beasley could not be here today because of the hurricane. He lives over in Houston and was hit kind of hard and lost a vehicle, my understanding is. But as soon as I can get to talk to him this week, if I can just have a couple weeks reset, well, he's got to come up with a little bit of money, but he needs to come over here to finish up the case.
Okay, now
If
let
I
me.
can have a regular reset.
Okay. Now you said that he has now the money that is to come up for the probation department. Do you know how much time he needs to raise that amount?
It's owing is about $2,000. But they've made a tentative offer that if he can come up with 500,
Okay.
that they would dismiss everything for time.
We would plead the time served.
Right, time served, $500 time served, and he'll be off probation and all the obligations.
Now, Mr. Beasley, did you hear that?
Yes, sir.
Now, how long would it take for you to gather the $500? How much time would you need?
I would say with my current situation, just say a month or less.
Oh. Okay, so what's else? Okay, so what we're gonna do, we're gonna give you a little bit more than we're gonna reset the case to August 21st. Is that enough time?
Yes, sir. Absolutely.
Okay, so this case will be reset to August 21st of 2024. Your attorney and your bondsman will be given your reset. Once you get your, stay in contact with your attorney and your bondsman. You're free to go. Thanks for being patient with us. And we hope that everything is well with you, considering the fact that you just went through a hurricane. We hope that, again, that, one thing that we're happy about is that you're here. You did not lose any life or limb, and property could be replaced.
Right.
Okay, so hopefully you have a speedy recovery to recover the property that you may have lost, may have been damaged by the hurricane. So stay in contact with your attorney and your bondsman. You're free to go, and you have a blessed day.
You too, Judge.
You can get your reset.
May I be excused, Judge?
Yes, you may.
Thank you.
Okay, okay, we have some young people who are here with the Know Your County Courthouse. Is that correct? Okay, what age group? What age group do we have?
16 and 17.
16 and 17? So we're talking what, 10 and 11th grade? 12th grade? Okay, that's good. Now, I do know one thing from participating in this program that Reverend Roberts that he's going to ask you some questions. Okay, I don't know if y'all have a notepad, but some of the questions that he's going to ask is based on what happened and what you observed here in court. Okay, now one of the things that you observed a lawyer by the name of Tom Burbank. He's just walking out. He was representing his client. He's a defense attorney. You see these other two lawyers here. They work for the Jefferson County District Attorney's Office. They are assistant criminal district attorneys. They're commonly referred to as prosecutors. We have Mrs. Haley Simmons. She's a prosecutor. And we have Mr. Andrew Hillble, who's a prosecutor. Now, they are attorneys that work for the Jefferson County District Attorney's Office. And their job is basically they prosecute cases, they represent the state of Texas in the cases that they handle. Mr. Burbank was representing his client who was the defendant here in this court. Now, you also see a gentleman sitting in that chair, that's Mr. Gary Gilliam. And Mr. Gilliam, he works for the probation department. Okay. And so he's a probation officer. Sometimes when people get their case finalized, they get placed on probation and they have a probation officer who supervises them. That's what his job is. He supervises people who are on probation. Now, the young lady that is sitting down with you with the police uniform on, she's our bailiff here in court, Miss Mosby. And we also have Miss Martin. She's a bailiff here and a transport officer. And I think Miss Martin has a special guest here in the person of her son. Now, let me tell you this here. The area that you're sitting in, remember this, we call that the peanut gallery. It doesn't mean you can bring peanuts here and eat, because this is not the Texas Roadhouse. That's the peanut gallery. Now you see that wall that's in front of you? Anybody have any idea what that's called?
The wall that's in front of you is what it is.
That little wall. You know what it's called? It's called the bar, B-A-R, bar. Now, lawyers, when they go to law school, after they finish college, they go 3 years of law school. And when they finish law school, they have to take a test. Okay, this test, when I took it, it was 3 days, a 3-day exam. And it covered various different subjects that you had in law school. The test that you take is called the bar, B-A-R. It's the bar exam. And before you can practice law as a licensed attorney, you have to pass the bar exam. And so once you pass the bar exam, you will be allowed to pass by that wall. You see there are 2 openings? Only people that can pass through that wall, like that young lady who just came through, is a lawyer. She's passed the bar exam. And so you're allowed to pass that area when you're a lawyer, or if you get permission from who? From the judge. That's correct. Now, the area that Miss Minaldi was sitting in, we call that the jury box. You see 12 chairs. 12 chairs is for district court. And in this court, we have 6 people, which is the county court at law. Now, anybody have any idea what a jury does? Anybody seen a trial and it's a trial by jury? And what? Right. They will listen to all the evidence, they listen to all of the arguments, and then they will deliberate, have discussions, and then they will decide whether to find you either not guilty or guilty. That's what the jury does. This chair right over here, what a microphone is, anybody has an idea who sits in that chair? Yes. A witness? That's right. That's called a witness stand. That's what witnesses testify. They testify from the witness stand. Okay? Anybody, now, where I'm sitting, anybody have any idea what this is called? Now, let me do this here. Anybody play sports? You play sports? And the persons who do not get into the game, where do they sit? On the bench. That's what this is called. Okay? I'm on the bench. This is called the bench because the people who are in the game, the combatants, the people who are fighting, is the prosecution and the defense. Okay, I'm on the bench. I'm watching the action. I'm watching what's going on. Okay, and so this is called the bench. Now that table, those two tables in front of you, do you know who sit at those tables? Yes. Right. Right. If it's a civil case, it's a plaintiff and a defendant. Okay. If it's a criminal case, it's the prosecution and the defendant. Okay. And so we call those tables counsel's table. The attorneys sit at the table and they'll sit at the table with their client. The defendant will sit there with his lawyer, and the state will sit on the other side with the state. The state lawyers will sit on the other side. Okay. Yes.
Come back. They have something they want them to see for his canines.
Okay.
I'm gonna bring it back up. 'Cause
Okay.
they haven't had much time here, but I want them, especially my son, to hear you.
Okay.
We'll be back.
All right. Okay. Okay, Mr. Gilliam, this will conclude the calling of the motion to revoke probation docket on today's date, July 10th, 2024. And Mr. Gilliam, you're excused and you have a blessed day.
Thank you, sir.
You're welcome.
That was not what,
Jefferson County Court at Law number 2 is back in session. The court is in session and cause number M331964. Case is style of state of Texas versus Gabriel Cody Heckelman. Mr. Heckelman, is that your full name?
Yes, sir.
Mr. Heckelman, would you please raise your right hand? Mr. Heckelman, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth shall help you God? Mr. Heckelman, you may put your hand down. How are you doing, Mr. Heckelman?
Good.
I'm doing fine, thanks for asking. Mr. Heckelman, you represented in your case by your attorney, Attorney Ryan Gertz. Attorney Gertz, how are you doing?
Great, Judge. Thank you.
Mr. Gertz, do you waive a record in Mr. Heckelman's case?
Yes, Judge.
Mr. Heckelman, I have before me on my computer a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Gabriel Cody Heckelman, on or about January 10th of 2022, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of driving while intoxicated while you operating a motor vehicle in a public place in Jefferson County, Texas, which is a Class B misdemeanor. To this offense, well, first of all, do you understand what you've been charged with?
Yes, sir.
And to this charge, how do you plead guilty? Not guilty or no contest. Now, you're pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you are guilty?
Yes,
Mr. Heckelman, I also have before me a document that is titled Misdemeanor Plea Admonishment, is also labeled as State's Exhibit Number 1. Do you recognize this document? On page 2 of this same document, there are a set of initials on a line next to a box that's checked guilty. The initials are GCH. You place your initials on this document.
Yes.
On the next page of the same document, there's a signature above the line that is titled Defendant. Is this your signature?
Yes, sir.
On the next document is titled Trial Court Certification of Defendant's Right of Appeal. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant? At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargaining case and you have no right of appeal. Do you understand that statement?
Yes, sir.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes.
I also have a document on paper that is titled Discovery Certification. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant? Mr. Heckman, before you signed and initial these documents that I just showed you, did your attorney go over these documents with you?
Yes, sir.
And did you read and understand everything that your attorney went over? And is everything in these documents true and correct?
Yes.
To the best of your knowledge? Mr. Heckelman, are you a citizen of the United States?
Yeah, for safe one.
Any objections?
We have no objection, Judge.
No objections. State's Exhibit Number 1 will be admitted. Mr. Gertz, you advised and counseled Mr. Heckelman. Is there any evidence that he is currently mentally incompetent to stand trial?
No, Judge.
And Mr. Heckelman, your attorney, Mr. Gertz, has advised and counseled you. Are you satisfied with his representation?
Yes.
Has he provided full, effective, and competent legal representation? Mr. Heckelman, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. And I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargaining agreement?
We do, Your Honor.
And what is the agreement?
For the defendant's plead guilty, the state has offered 1 year deferred probation with $1,000 fine, 80 hours community service, the installation of an interlock device, and DWI standard conditions of probation.
Ms. Jackson, what is the court cost? $392. Okay, Mr. Heckman, the state is offering that you serve 1 year deferred adjudicated probation. During a 1 year probationary period, you'll be required to pay a fine of $1,000 plus a DPS fine of $100. You'll be required to pay court costs of $392, probation fee of $60 a month, urinalysis fee of $15 a month, reimbursement fee of $15. You will also be required to pay Jefferson County DWI initial evaluation and DWI education fee of $125 on the day of the plea. Should a further evaluation be needed, you'll be required to pay an additional $50. Your total monthly installments, that is the total amount that you'll be required to pay each month while you're on probation, is $219 a month. Will you be able to pay the $219 a month?
Yes.
You will also be required to perform 80 hours of community service. You'll be required to install the interlock device on any vehicle that you want to operate. You'll be required to attend a completed DW education class. You're required to have an alcohol assessment, and you'll be required to adhere to the other standard terms and conditions of DWI probation. Mr. Heckman, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes.
And do you accept the state's offer?
Yes.
Mr. Heckman, I'll follow the plea bargaining agreement that you have entered into with the state. Now, Mr. Heckman, if you successfully complete this probationary period, this case will be dismissed. It will not result in a conviction on your record, and you may qualify for non-disclosure. You can talk to your attorney, Mr. Kurtz, about the non-disclosure because he's quite competent in those matters. Now, Mr. Heckman, you're gonna stand in front of the court coordinator, follow her directions. Once you finish following her directions, you'll be free to go, and you have a blessed day. This is.
Yes.
Eric Corbin,
Yeah, I'll do my best. Not just but I mean, that's exciting. So you say ready?
Eric Corbin,
Probably.
Hey, Cody, call me if you have any problems with that.
Just go see that one now. Nothing, I'm sorry, he's still my things. Judge still there. I'm gonna file a case on that.
oh, here we go. Court is in session in cause number 23 CCCR 1286. Case is styled the state of Texas versus Eric Corbin. Mr. Corbin, is that your full name?
Yes, sir.
Mr. Corbin, would you please raise your right hand? Mr. Corbin, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Corbin, you may put your hand down. How are you doing, Mr. Corbin? I'm doing fine, thanks for asking, Mr. Corbin. You're represented in your case by your attorney Reagan Minaldi. Ms. Minaldi, do you, first of all, how are you doing?
I'm good, Judge, how are you?
I'm doing fine, thanks for asking. Ms. Minaldi, do you waive a record in Mr. Corbin's case?
We do, Judge.
Mr. Corbin, I have before me a document that has been filed by the Jefferson County District Attorney's Office. This document is titled Information Sheet. In this information sheet, it alleges that you, Eric Corbin, on or about February 17th of 2023, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of possession of a controlled substance penalty group 2A less than or equal to 2 ounces. Mr. Carpenter, do you understand what you have been charged with?
Yes, sir.
And to this charge, Mr. Carpenter, how do you plead? Guilty, not guilty, no contest?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you are guilty?
Yes, sir.
Mr. Carpenter, I also have before me a document that is titled Misdemeanor Plea Admonishments. It is also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there are a set of initials on a line next to a box that said guilty. The initials are EC. Did you place your initials on this document?
Yes, sir.
On page 3 of the same document, there's a signature above the line that is titled Defendant. Is this your signature?
Yes, sir.
And on the next document that's titled Tropical Certification of Defendant's Right of Appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? I also have a document that is titled Discovery Certification. Do you recognize this document? And is this your signature on the line that's titled Defendant? Mr. Carpenter, before you signed and initial these documents, did your attorney go over these documents with you?
Yes, sir.
And did you read and understand everything that your attorney went over?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Carvin, are you a citizen of the United States?
State offer states one. No objection.
No objection. State's Exhibit Number 1 will be admitted. Ms. Minaldi, you've advised and counseled Mr. Carvin. Is there any evidence that he is currently mentally incompetent to stand trial?
No.
And Mr. Carvin, your attorney, Ms. Minaldi, has advised and counseled you. Are you satisfied with her representation?
Yes, sir.
Has she provided full, effective, and competent legal representation?
Yes, sir.
Mr. Carvin, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable state. Do we have a plea bargain agreement?
Yes, Your Honor.
And what is the agreement?
In exchange for defendant's plead guilty, the state's offering 70 days in the Jefferson County Jail, credit for 70 days, and 2 tax and retire all court costs.
Okay, Mr. Carvin, the state is offering that you serve 70 days in Jefferson County Jail. However, you will not be required to serve any more time in the Jefferson County Jail on this case because you've already served 70 days in Jefferson County Jail. Therefore, you'll be given credit for the time that you've already served. The court costs in this case will be taxed and retired. That simply means that you will not be required to pay the court costs because the time that you have spent in jail has already paid off the court costs. Therefore, the court costs will be taxed and retired. Mr. Carvin, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Mr. Carvin, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Carvin, you're gonna stand in front of the court coordinator, follow her directions. Once you finish following her directions, you can follow the bailiff and you have a blessed day. And Ms. Minaldi, this is the last case.
Yes, sir.
You're free to go and you have a blessed day.
Thank you, Judge. Your Honor, I also sent the dismissal in one of Ms. Minaldi's cases. I don't know if she wants a copy.
I know, right?
This is a new case.
Yeah, I just figured.
Okay, she was,
I did.
okay, the next case is cause number 23 CCCR 2470. Case of style of state of Texas versus Debbie Bout. And Ms. Bout is not present, however, her attorney is present, Ms. Minaldi. And state, I have before me a motion to dismiss the case. Is that correct, state?
Yes, Your Honor.
Okay, Ms. Minaldi, I'm signing the dismissal.
Thank you, Judge.
You can get a copy of the dismissal in a few seconds.
Excellent. Thank you
Just
so much.
please stand in front of the court coordinator.
Appreciate it.
All right, you're free to go. Okay, this is, call number M328-422, case of style of state of Texas versus Casey Harden. Ms. Harden, is that your full name?
Yes, sir.
How are you doing, Ms. Harden?
Doing fine. How are you?
I'm doing fine, thanks for asking. Ms. Harden, you're represented by your attorney David Grove. Attorney Grove, how are you doing?
I'm doing good, Judge. Thank you.
You're welcome. Now, Mr. Grove, what's your announcement?
I'd like to ask for a resetting of about a month or so I can do some more investigation.
Okay, well, this case has been around a while. We're gonna give you a 30-day reset.
That's fine, Judge. It's what I learned some new facts today that I wasn't aware of.
Okay, this
August 12th?
case is gonna be reset to August 12th. Let's put it on a,
I have surgery. I have a surgery coming up. I'll just be getting out the hospital. I'll just be leaving.
you say you have a surgery?
Yes,
And
sir.
so she said she's gonna get out of the hospital on August the
Obviously,
11th.
But anything after that week is fine if possible.
Or we can put it up, we can push it up before the surgery.
It just depends on.
Okay. We can push it up before the surgery.
Judge, I just needed time to investigate.
Okay.
several things that have come up.
Yeah, because I'm saying this it thing is just a 2020
Even
case.
if it's that the week of the 11th, that Friday, just I mean, like that week of, that's still fine. I just know I get out on the 11th and the 12th to be a little, because I live out of town.
I understand, I'm saying.
What about-
Let me say today is the 10th, July 10th. You have surgery on the 11th, right?
I have on 8th, but I'll get home on
Oh, you're having it on the 8th.
August the 8th, and
Oh, I
I'll
didn't
make it
know
home on August the 11th.
What's the week after that? Does that be enough time for you to recover?
Yes, sir, most definitely.
Okay, this case will be reset to August 19th. Put it on, what docket did we have on the 19th?
Announcement trial.
Might have to put it on a pretrial conference docket. Yeah,
That's fine, Judge, whatever.
okay, this case will be reset to August 19th, 2024. Ms. Horton, your attorney's gonna get you reset. Once you get your reset from your attorney, you're free to go. You have a blessed day, and hopefully you have a speedy recovery from your surgery, and we hope that everything turns out fine with your surgery.
Thank you, and you have a blessed day.
All right, same to you. Mr. Rowe, you can get your reset. You
Thank
get your
you.
reset, you're free to go, and you have a blessed day.
Thank you.
Yeah. You know I will, right? Okay.
Did we check on, you gonna send her reset? Mr. Grove, you gonna send her reset?
Yes, sir, I'm
gonna give Oh, she went outside. Oh, okay. Okay, now,
I am, brother.
court is back in session in two cases. Cause number M332144 and cause number M332146. Both cases are styled the state of Texas versus Charles William Ritchie Jr. Mr. Ritchie, is that your full name?
Yes, sir.
How are you doing, Mr. Ritchie?
Doing well. How are you?
I'm doing fine. Thanks for asking. And Mr. Ritchie, you're represented by your attorney, Attorney Ryan Gertz. Attorney Gertz, what is your announcement in Mr. Ritchie's case?
Judge, we are close to resolving it with a plea deal, but we don't have it done yet. So we're either asking for additional time, or if the court would prefer to put it on the trial docket, given its age, we'll do whichever the court
Yes.
prefers, or a pre-trial docket.
Okay, we'll put it on the trial docket.
Okay.
And give us a trial date, August 12th. Okay, Mr. Ritchie, these cases will be reset until August 12th, 2024, on the trial docket. The attorney's gonna get you reset. Now, before your attorney gives you a copy of the reset, I'm going to go over some bond conditions with you.
Yes, sir.
And you'll be able to get a copy of these bond conditions once we make a copy of it. The document is titled Standard Bond Conditions in County Court Law Number 2. Following return of criminal information in County Court Law Number 2 of Jefferson County, Texas, all bail bonds executed for the release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition? Yes, condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond of any person or any defendant who A, refuses, who refuses to submit to a drug or alcohol test, or B, submit to a drug and alcohol test, and the test indicates the presence of drugs or alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
Let's see. Condition number 5 states that the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by section 1.07 of the Texas Penal Code, actively engaged in employment as a sworn, full-time, paid employee. Do you understand that condition? Let's see. Okay, now, Mr. Ritchie, if you violate any one of these bond conditions, your bond can be revoked, and if your bond is revoked, a warrant will be issued for your arrest. Do you understand that? Sir. Let me search.
Judge, may I ask for a slight amendation to the bond condition number 5 that you just read? Related to the firearm?
Okay, the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn, full-time, paid employee of a state agency or political subdivision.
I sort of have a constitutional objection to that generally, but
Okay.
my question, I guess, is could we amend it to say other than in his home? Because I mean, he's allowed to own a gun in his home.
Well, these are the bond conditions. I mean, you
Well,
have your objections, you can make your, you can appeal it to the Ninth Court of Appeals or whatever, but these are the bond conditions.
Okay. Well, what I'd like to do then is have the court's permission to file a writ and have a formal hearing about that issue, because
Well, you can follow it. That's your choice, but these are the conditions. His other condition, I was just reading the PC, states that as a defendant whose information charges any subsequent, well, it's gonna be any offense listed under 49B, or excuse me, 4904 or 49C of the Texas Penal Code shall not operate a motor vehicle unless the vehicle is equipped with an interlock device mechanism that makes it practical to operation of the vehicle if ethyl alcohol is detected in the breath of the operator, and said device shall be installed at the defendant's expense with written verifications of such installation being submitted to the court on or before. That'll be 3 days after the day.
And he's in compliance with that, Judge, and has been.
Yes, sir.
Okay, that's good. Okay, that's good. I just didn't have for some reason, there was not a written order. There was no written conditions of bond. So I'm just, okay, so that's good that he has it. The only thing we need to do is have you or him to send us proof that he has the interlock.
And just give it to them all. Sure.
Yeah, okay.
Yes, sir.
State, you have any objections or any agreements that you made?
In regards to the bond conditions, Your Honor?
Yes.
I mean, none other than to reiterate what you had said, these are the standard bond conditions that apply in all cases. There's no reason to amend them for this, in this specific case.
Okay. Now, what is this court? Did we get a court date on it?
Yes, Judge, August
Okay,
12th.
okay, all right, all right. Yeah, but you gave him you need to give him you're gonna get a copy of your bond condition. Once you get a copy of your bond conditions from your attorney, you're free to go and you have a good stay. Thank you. You're welcome. Who we have next? Ms. Milo. That's your last case?
For me, Judge.
Yeah, you're free to go and you have a blessed day.
Thank you, Judge.
Oh, yeah, she'll give you a copy. Jamie Trinell Milo.
Is that your case of adjournment?
You get it?
Miss Milo, your full name is Jamie Trinell Milo?
Correct.
Okay, Miss Milo, would you please raise your right hand? Miss Milo, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Miss Milo, you may put your hand down. How are you doing, Miss Milo?
Not fine.
That's good. Now, Miss Milo, you're represented in your case by your attorney, Attorney Rife Kimler. Attorney Kimler, how are you doing?
Well, thank you, Your Honor.
That's good. Now, before we get started, I think Ms. Milo has been in court before, is that correct? On some other cases that we've had in this court. And then, in those cases, I, informed the court that I know Ms. Milo. Is that correct?
Yeah, you have previously, you didn't do it today, but you have previously.
Right, right.
Yes, sir, it's on. the
And,
record.
but we've had so many different prosecutors. I don't know if, she wasn't here at the time. So basically, I know Miss Milo. I think I know, I had a friend of mine whose deceased was married to Mrs. Milo's sister. And, now I never talked to you about your case. Is that correct?
No, sir.
Okay. And never made you any promises or anything regarding your case or any cases that the court has had? Okay. Now, the fact that I know Miss Milo state, if you want me to recuse myself, because based on that maybe a impropriety, an appearance of impropriety or a conflict of interest, the court will be willing to recuse itself.
Now the state sees no conflict here, Judge.
Defense, you have any objections?
No objection.
Okay, no objections. So, Ms. Milo, I have before me a document that is titled information sheet. This information sheet was filed by the Jefferson County District Attorney's Office. In this information sheet, Ms. Milo, it alleges that you, Jamie Trinell Milo, on or about March 4th of 2023, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of driving while intoxicated while you are operating a motor vehicle in a public place in Jefferson County, Texas. Ms. Milo, do you understand what you have been charged with?
Yes, sir.
And to this charge, Ms. Milo, how do you plead guilty, not guilty, no contest?
Guilty.
Now, are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you are guilty?
Yes.
Ms. Milo, I also have before me a document that is titled Misdemeanor Plea Admonishments, also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes.
On page 2 of this same document, there are a set of initials on a line next to a box that said guilty. Did you place your initials on this document?
Yes, I did.
On page 3 of this same document, there's a signature above the line that is titled Defender Signature. Is this your signature?
Correct.
And on the next document, that's titled Trial Court Certification of Defendant's Right of Appeal. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
The second box that's checked states that you are waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, I do.
I also have before me a document on paper that is titled Discovery Certification. Do you recognize this document?
What's that for?
Discovery Certification. Do you recognize this document?
Yes, sir.
And is this your signature on this document?
Yes, it is.
Now, before you sign and initial these documents, did your attorney go over these documents with you?
Yes, it is.
Okay, and did you understand everything that's in these documents?
Yes.
And is everything in these documents true and correct to the best of your knowledge?
Yes, I do.
Ms. Milo, are you a citizen of the United States?
Yes, sir.
State,
No objection.
no objections. State's Exhibit Number 1 will be admitted. Mr. Kimler, you advised and counseled Ms. Milo. Is there any evidence that she is currently mentally incompetent to stand trial?
No, Your Honor.
And Ms. Milo, your attorney, Mr. Kimler, has advised and counseled you. Are you satisfied with his representation?
Yes, I am.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Ms. Milo, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor.
And what is the agreement?
In exchange for defendant's plea of guilty, the state's offering 90 days probated over 1 year, $250 fine, 60 hours community service, DWI standard conditions, and court cost.
DWI first,
DWI first, correct.
.08. Yes. Just make sure.
There's not- it's not on the report.
Is this gonna be dismissed off my record?
No,
This was on my record.
Okay, now, okay, what is our co-cost? 392. Just 1 year.
that's the fine. She's already on felony probation.
Oh, she is?
I'm on misdemeanor
Oh,
probation.
Miss, I'm sorry. I thought you were on.
No, misdemeanor probation.
Okay.
We got my felony job.
All
Johnson.
right.
Okay, okay. Okay, hold on a minute.
So she won't have additional probation fees, it'll just be the fine and court cut and whatever assessments. So you can take it up to $16. It'll just be. Well, and whatever assessment.
Yeah.
Yeah, I think yes. So I try to get the fine. Start stacking.
All those go to probation fees.
Hmm?
All those gonna go to probation fees.
Mhm. Now, grab your by your ankles and shake. See if you can't fall over your body.
Who's changed?
I'm to my probation officer, me and my probation officer got a plan, baby, and I'm sticking to it. In Jesus' name. Thank you.
Praise Jesus.
You know,
Hmm?
you're rubbing blue, back up to you, it's you.
You better look at it. Not what a stupid hat either.
You did try it on, right?
So,
After we leave here. Oh, he's not gonna find it at Walgreens.
Okay,
go to the fees.
now, Miss Milo,
Yes, sir.
the state is offering that you serve 90 days in Jefferson County Jail. However, you'll not be required to serve any time in the Jefferson County Jail because you'll be placed on probation for a period of 1 year. During the 1 year probationary period, you'll be required to pay a fine of $250 plus a DPS fine of $100, court costs of $329. You'll also be required to pay probation fee of $6,000 a month, year fee of $15 a month, and a reimbursement fee of $15. Now, you also be required to pay Jefferson County DW Education Initial Evaluation fee of $125 on the day of police. Should a further evaluation be needed, you'll be required to pay an additional $50. Now, the total monthly installments, including the probation fees, the probation, with the probation fees, the urinalysis fee and the reimbursement fee is $145 a month. However, because you are already on probation, you'll be the probation fee, the urinalysis fee, and the reimbursement fee, you will not be required to pay that. However, you will be required to pay the fine of $250, the court cost of $329, and the DPS fine of $100. Your total monthly installments will be $62 a month.
That's in addition to what you're already paying.
$62 a month. Would you be able to pay that?
Yes, sir.
Now, the paperwork that you will be receiving will have the probation fees, your analysis fee, and the reimbursement fee included in it. But your probation officer, you're gonna have the same probation officer. Once you show the probation officer that you received probation, you will not be required to pay the additional probation fee, the reimbursement fee, and the analysis fee. Do you understand?
Gotcha.
Okay, so don't get confused when you see it in your paperwork.
Yes, sir.
All right. Now, you will also be required to perform 60 hours of community service. You're required to attend and complete a DWI education class. You will required to have an alcohol assessment, and you'll be required to adhere to the other standard terms and condition of this DWI probation. Ms. Milo, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes.
And do you accept the state's offer?
Yes, I do.
Okay, Ms. Milo, I'll follow the plea bargain agreement that you have entered into with the state. Ms. Milo, this will conclude your case. Please stand in front of the court coordinator and follow the directions of the bailiff. Once you finish following the directions of the bailiff, you'll be free to go, and you have a blessed day. And Mr. Kimler, I think.
That's it. Ms. Baker's in TDC. She's got she's been benchmarked on a felony, so I'll take care of that.
Oh, okay.
Thank you. Thank you.
Okay, you're welcome. So we're gonna set Baker on the same day of the felony, which is August the 1st.
Yeah, that's what it said.
It says August the 1st.
Actually, but I'll think if it's set first, I'll figure to take care of that.
Okay, okay.
Thank you. No, thank you.
You're the last one, Mr. Reynolds.
Okay, let's see.
Yeah. My God, Miss working what I'm saying about it. Are we ready for him, Judge?
I don't have, wait up, is that Young?
Yes.
Yeah, I have the paperwork. He can come on up.
They're at lunch right now.
Ready for food. You just get it where you need.
Since it's two different things.
I mean, no, I don't even.
We have to go this.
Okay. Jefferson County Court, law number 2 is back in session. The court is in session in clause number 24 CCCR 0746. Case is styled the state of Texas versus Joseph Aaron Young Jr. Mr. Young, is that your full name? Mr. Young, would you please raise your right hand? Mr. Young, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes.
Mr. Young, you may put your hand down. How are you doing, Mr. Young? That's good, Mr. Young. You're represented in your case by your attorney, Attorney Nathan Reynolds. Attorney Reynolds, how are you doing?
Doing well, Judge.
That's good. Now, Mr. Reynolds, do you waive a record in Mr. Young's case?
So wait.
Mr. Young, I have before me a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, Mr. Young, it alleges that you, Joseph Aaron Young Jr., on about January 6th of 2024, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of resisting arrest, search, transportation. Mr. Young, do you understand what you have been charged with? And to this charge, Mr. Young, how do you plead guilty? Not guilty or no contest? Now, you're pleading guilty freely and voluntarily? And are you pleading guilty because you are guilty? Mr. Young, I also have before me a document that is titled Misdemeanor Plea Admonishment, is also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes.
On page 2 of this same document, there are a set of initials, JY, on a line that's typed, where the box is checked guilty. Did you place your initials on this document?
Yeah.
On the next page of the same document, there's a signature above the line that's titled defendant. Is this your signature?
Yeah.
And on the next document that's titled trial court certification of defendant's right of appeal, do you recognize this document?
Yeah.
And is this your signature on the line that's titled defendant?
Yes.
At the top of this document, there are 2 boxes that's checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes.
Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes.
I also have before me a document on paper that is titled discovery certification. You recognize this document?
Yes.
And is this your signature on the line that's titled defendant?
Yes.
Mr. Young, before you sign and initial these documents that I just showed you, did your attorney go over these documents with you?
Yes.
And did you read and understand everything in these documents?
Yes.
And is everything in these documents true and correct to the best of your knowledge?
Yes.
Mr. Young, are you a citizen of the United States?
Yes.
State,
Offer states one.
any objections?
No objection, six one.
No objection, states exhibit number 1 will be admitted. Mr. Reynolds, you have advised and counseled Mr. Young, is there any evidence that he is currently mentally incompetent to stand trial?
None to my knowledge, Judge.
And Mr. Young, your attorney, Mr. Reynolds, has advised and counseled you. Are you satisfied with his representation?
Yes.
Has he provided full, effective, and competent legal representation? Mr. Young, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor.
And what is the agreement?
In exchange for defendant's plea of guilty, the state's offering 56 days in the Jefferson County Jail, credit for 56, and to tax and retire all court costs.
Okay, Mr. Young, the state is offering that you serve 56 days in Jefferson County Jail. However, you will not have to serve any more time in the Jefferson County Jail on this case because you've already served 56 days in Jefferson County Jail. Therefore, you'll be given credit for the time that you've already served. The court costs in this case will be taxed and retired. That means that you will not be required to pay the court costs because the time that you spent in jail has already paid it off. Therefore, the court cost is taxed and retired. Mr. Young, do you understand the state's offer?
Yes, sir.
And do you think that the state's offer is fair and just? And do you accept the state's offer?
Yes, sir.
Mr. Young, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Young, you're gonna stand in front of our court coordinator, follow directions of the bailiff. Once you finish following the directions of the bailiff, you can follow the bailiff, and you have a blessed day. And Mr. Reynolds, this will conclude your case. You're free to go, and you have a blessed day.
Okay, you too, Judge.
Okay, Mr. Young, you have a blessed day as well. This will conclude the calling of the court's motion to revoke probation docket, the court's announcement docket, both dockets scheduled on today's date of July 10th, 2024 in County Court at Law number 2 of Jefferson County, Texas. Judge Terrence Holmes presiding. Everyone, please have a blessed day.